Okay, starting with the Sanhedrin, Daf 23, onward, Aleph. Dine Maimanis Vishleisham. The case is a monetary law. We're going to be looking at cases of monetary law and their judgment being judged by 3 judges and the selection process of these judges. They're chosen in the following manner. This litigant chooses one for himself, and the litigant and that litigant chooses one for himself. Ushnekan boirim lachan oy achad divrei Rabbi Meir. This is the statement of Rabbi Meir. The Chachamim oimrim, the Chachamim, the sages, the rabbis say, Shnei the yanin boirim lachan oy achad. The 2 judges that were chosen choose one more judge for themselves. So Rabbi Meir is saying that when 2 proponents come to the court to litigate, one litigant chooses one judge and the other litigant chooses one judge. And the 2 of them together choose one more so that it comes to a total of 3. The rabbis say the 2 judges that were chosen choose one more judge for themselves. So what is the difference? What is the nafkamina? The assertion that the judges are chosen by the litigants seems to contradict the halacha that a court can compel litigants to appear before the court of judgment. One resolution offered is that a court can compel a litigant to appear before it only if he refuses to go to court altogether. But if he requests to be judged in a different court, he has the right to choose a different court. So the judges cannot compel him to be subservient under particular judges. The litigants have some leeway as to who the judges are. And the halakha is, if one of the litigants say, let so-and-so act as a judge for me, and the other litigant says, let so-and-so act as a judge for me, the 2 judges who are chosen by the litigant choose a 3rd judge. And the 3 of them adjudicate the case of the 2 litigants. In this manner, a true judgment will emerge. This is Rabbi Zera's opinion. The 3rd judge does not require the approval of the litigants, in accordance to Rav's interpretation and in the Rav's interpretation of the opinion of the rabbis. So it seems like they are allowed to choose one for themselves, and the 2 judges would then choose a 3rd. It's unclear to me why the rabbis would reiterate this latter point unless they're trying to highlight something. Perhaps it will become clear as we go. Zeh paisel dayanai shel zeh b'zeh paisel dayanai shel zeh. This litigant can disqualify the judge chosen by that litigant, and that litigant can disqualify the judge chosen by this litigant. Divrei Rabbi Meir, this is the statement of Rabbi Meir. The Chachamim oimrim, and the rabbis say, a masai, when can one of the litigants disqualify the judge? Zman, only when shemevi aleikan revaya shechem keruvim pasulim. Only when he brings evidence about them, that they're related to one of the litigants or to each other, or that they're disqualified from serving as judges for another reason. Meaning that if there is some family relation, or perhaps some other disqualifying relation, then they would be disqualified. Avalim, but if hayu keshedrim u moimkin mipi based, but if they're fit to serve as judges or experts ordained by the court, einu yakal, lefaislan. He cannot disqualify them. If they're fit to serve as judges or are experts ordained by the court, he cannot disqualify them. Now, it's unclear to me that if they were ordained by the court, but if they have disqualifying relationships, would that still disqualify them, or would it protect them? Would them being court appointed protect them? Ze paisal Adav Shalzam, the litigants can disqualify the witnesses of that litigant, and that litigant can disqualify the witnesses of this litigant. V'zeh paisal Adav Shalzah. This is the statement of Rabbi Meir. Divrei Rabbi Meir. The Chachamim and the rabbis say, Oimrim a Masai. When can one litigant disqualify the other's witnesses? Bisman she'meivim aleikam ra'aya shechein keruvim al psulim. Only when he brings evidence about them that they're related to one of the litigants or to each other. Same kind of disqualifying factors. Rabbi shehem keruvim u psulim. They're disqualified from bearing witnesses for another reason. But if they are fit to serve as witnesses, avalim hayu kesherim, that they're kosher, einu yachal lefaisla, he cannot disqualify them. The Gemara assumes that the statement into the discussions of the Gemara, this litigant and that litigant chooses one, and if two of them choose one more, it means that each litigant chooses a court of three judges, and two courts together choose one more court. So that may be what it's actually meaning, is that they're choosing different courts, well, two courts together, for a total of 9 judges. For what purpose does this litigant choose one court for himself, and that litigant choose one court for himself? Isn't it sufficient to judge the cases? The commentary here brings down that perhaps the Gemara is assuming that they're not choosing judges per se, but choosing courts. Choosing judges means choosing courts. Does it say clearly? It doesn't say clearly here. It says chooses one for himself and chooses one for themselves. It doesn't specify, except here, about disqualifying judges. So when it's not specified, it gives the room for the Gemara to make this assumption. But we know that the final halacha is that they're actually choosing judges. Mai zirei loy echad bezeh boirei loy echad bislasan sagi. Chafi ka'amar. The Gemara answers, this is what the Mishnah means. Kashazeh boirei loy bezdin echad. In a case where this litigant chooses one court for himself, he requests to be judged before specific judges, and that litigant chooses one other court of 3 judges for himself. As he does not wish to be judged before the court that the first litigant requested in this case. Both of them choose one more court for themselves. Both courts choose one more court for themselves. They must reach a compromise and decide about the composition of the court that will judge them. Here, it means that both courts work together to choose one more court. Vafilu leiza matse ma cave. The Gemara asks, and can even a debtor restrict the choice of the court? A person who owes money restrict the choice of the court? Ha'amar Rabbi Elazar. But doesn't Rabbi Elazar say, Loi shanun ala? The sages taught that only a creditor is a court chosen by the debtor. due to his desire to be judged by a prominent court. But that for a debtor, Aval lezeh koifin oisoi b'dan b'ijrei, they compel him to appear in the court that presides in his own city. So the question is raised. We assume that a creditor can refuse a court and be discerning about which court because he is desirous of a more prominent court. For a person who owes a debt, they compel him to appear in the court that resides in his own city. Hopefully, the questions to expound on the meaning as to why one has an advantage and one doesn't. Kid Amar Rabbi Yochanan. It is as Rabbi Yochanan says concerning a different matter, that the sages taught that other matter with regard to the layers Barakayas in Syria. Barakayas Shkasuria Shanu. Chacha Nami. Here too. Barakayas Shabasuria Shanu Aval Maikin Lai. Here too, the sages taught the halakha in the Mishnah with regard to the layman's court in Syria, which allow even the debtor to refuse to be judged before the court chosen by the creditor, claiming that they are not worthy judges. But if the creditor chooses a court of experts, the debtor does not have the right to refuse to be judged before them. So looking at this again, Rabbi Yochanan says about a different matter, that the sages taught that the other matter with regard to layman's courts in Syria. So perhaps what is meant above about the debtor not having the privilege to refuse a court is relevant to Syria too. The sages taught the halakha in the Mishnah with regard to the layman's court, which allow even the debtor to refuse to be judged before. Those courts may be more lenient for the debtor, that he discerning that he has the privilege. But if the creditor chooses a court of experts, the debtor does not have the right to refuse. The experts nullify that privilege of the debtor. You see the notes here. Archaios, apparently from the Greek arche, meaning magistracy. The use of the letter ayin in the Hebrew spelling may be a result of the similarity in meaning to the Hebrew word erech, value, or arika, arrangement. So this word is related to the different Hebrew roots, erech or arika. With regard to the layman's court in Syria, Barkais, Shkasuria, why were those who were not proficient in halakha allowed to serve as judges? Some commentaries explain, based on the Gemara in the first chapter, that one of the three common people is presumably proficient. Others claim that even if all were unlearned, they were allowed to serve as judges because the community accepted them. So in Judaism, people are allowed to appoint judges, and the judges don't necessarily have to be qualified, though they have to be Jewish. And here is a discussion about who is considered a qualified judge and who is not. And of course, any judgment that a court issues would have to include both litigants, and both litigants' claims have to be heard. People like to, the Yetzer Hara in people is to run to the judges and to give over your point of view, and because your point of view came first, that has an advantage in the minds of judges. That is a side note and a point of interest in terms of properly regulating the orders of justice. We'll stop here.